Welcome back to the Morning Brief right here on Channels Television. So we begin with the judiciary this morning with that particular concern about, contradicting judgments from courts of coordinate jurisdiction. And as a result, many have raised an issue with the judiciary, saying it faces a crisis of confidence, even integrity, with insinuations that it is being subdued beneath the influence of the executive. So what's the way forward? How do we reform the judicial process? And particularly, what's the task before the CJ and as she summons judges, to come explain this worrisome pattern? Joining us to have this discussion this morning is Mr. Malachy Ugwumadu. Is a legal practitioner. Good morning, and thank you so much for coming through for us, Mr. Ugwumadu.
Good morning, Bukola. Good morning, viewers.
Yes, indeed.
It's a privilege to be here. Thank you.
I'd like to start from the source, or what some would say perhaps is responsible, for the overbearing influence of the executive on the judiciary. Of course, we know that the executive withholds the right to appoint very important offices. For instance, the office of the CJN, even the chief judge of the state, and even state attorney generals as well. What would you be proposing as an alternative, if we could deal with that source, as an alternative to the emergence of critical offices of members of the judiciary, such that they can be insulated from the influence of the executive?
Bukola, that's a very... I'm tempted to believe that you're a lawyer yourself with this kind of question. Goes to the heart of a very vexed issue that has attracted the attention of the legal profession as a body, but more importantly, critical stakeholders, considering that what your question has attacked is the entry point, the recruitment process, which is at the provenance, which is at the source and beginning of the character of the judiciary that we have. It's quite very, very important. Now, you are right in identifying that the executive plays a role. But please make no mistake about it. It is an interplay of the organs of government in the recruitment of judicial officers in Nigeria as it stands today. If you take a look at the constitutional provisions regarding the appointment of judges and justices at the federal level, and I'm referencing section 231, 238, 250, 254, talking about the National Judicial Officers, 256, 261, and 266. You could see I'm looking at my paper because I had cause to present a paper in respect of this aspect of our challenges before the Presidential Advisory Committee on Anti-Corruption, that, moved into the judiciary to find out exactly what it is. So, the National Judicial Council recommends. The president appoints. The legislature, specifically the Senate, confirms. You could see that tripod approach to it. And if you listen carefully, it is not just about the judiciary. The National Judicial Council, well, you could say, an executive body. The president, of course, is the head of the judiciary itself. Of the country, of the executive itself. But the Senate is the legislature. So the way it is designed is to secure some measure of transparency, accountability, but more importantly, to be able to identify proper and fit officers, judicial officers, who will be able to superintend the affairs of the judiciary of that nation. And it is very, very crucial. These should be men of sufficient knowledge, patriotism, and above all, the sense of justice and the courage to do justice regardless of whose horse is gone. And that's why we say, justitia fiat colem. Let justice be done, even if the heavens would fall. So, if you take it from that angle, you will see the seriousness paid to the recruitment process on paper, in the Constitution, as a society. But the issue now is, to what extent has this helped to take care of the influences and the manipulation and the interference that you talk about? That is the issue. That is the elephant in the room. So once we have, first of all, identified that this problem exists, the challenge will be, what is the way out? And that is directly in response to your question, where you say, how do we therefore address this? For me, it's not too complex. It's not a rocket science. The first is that Nigeria as a country must take seriously the recruitment process of our judges and justices very seriously, and commit to that position that there should be little or no interference, particularly political interference. Because if that is allowed, what it does is to contaminate the entire judicial system from the source. And when we talk of interference, it is about the influence peddling that we're all used to and we all know in this country. That could happen at peripheral, pedestrian axis of our nation. But if it goes into the judiciary, we're all done for it. And what I mean by that is that appointments shall be strictly by merit and not patronage. Where you now hear that children, offsprings, relatives, friends of maybe judicial officers sitting or retired now make their way to the judiciary and to the bench, even when they are not even, first of all, disposed, let alone possessing the deep legal knowledge to be able to discharge that onerous responsibility that they bear and owe the country. And secondly, there must be very clear and settled and certain procedure and processes of this recruitment. Thirdly, it must be part of the consideration to have, if you like, a more competitive process and engagement, just so that it is no longer circumscribed and limited to just the career judicial officers who will naturally. It is true that people grow on the job and learn on the job. However, there are very many Nigerians, legal practitioners, who have distinguished themselves in the course of their professional career and who have come to the pinnacle of their practice and are ready to assist this country by bringing their wealth of knowledge and expertise to bear in the judicial sector. Such people should be given the opportunity. In fact, it is not new. Very many years ago, particularly around the independent era, we had so many justices who were not judges, but moved onto the bench. Taslim Elias is one of such. You could also remember that Nigeria outsourced a lot of judicial officers to superintend their judicial system of so many other countries, Uganda in particular, and so on and so forth. So, yeah.
I just need to butt in. I know you've established strongly some of the entry point, because that's what you're talking about, how we can help out in terms of entry point for judicial officers and ensure that the right persons come in with all the checks and balance that is required. The reason why this conversation is very, very, very important, I was processing it last night and I thought to myself, if we get the judiciary right, because we're talking public institutions, literally all of them have flags of that we can talk about, downsides that we can talk about, and some are overwhelming downsides. So you can go to INEC, you can go to the police, you can go across board. And so sometimes it's quite difficult to see, where do we even start from? The judiciary is one of those places where it's troubling to see what plays out, because when you see some things that happen, you're asking yourself, what exactly is happening here? So I feel that if we get the judiciary right, which is the last hope of the common man, whatever recklessness is being peddled across every other sector ends up in court. If we have the right persons, then we have hope. If the courts start correcting people the way they should be corrected, then everybody will start behaving themselves. So my question is, some basic fundamentals that we see happen, and I don't know whether it's mistake or error or just pure mischief. So, for instance, now the Chief Justice of Nigeria, Justice Kudura Kekereko, has summoned the Chief Judge of the Federal High Court, Justice Soho, and I think the Chief Judge of Rivers State, that the issue has to do with the political impasse that has, troubled Rivers State for a very long time. And the simple question he has to answer, Justice Soho, is the fact that literally every state has a Federal High Court division in their state. How come cases in Rivers State that has to do with Federal High Court find itself in Abuja? So I want you to put that at the back of your mind and maybe help us understand, how does that play out? And then I've also read judgments and seen even the appellate court, the court of appeal, reprimanding the lower court, where a litigant or a lawyer will take a case to a judge, and the judge clearly knows that this case is out of my jurisdiction. So rather than sometimes speak to the merit of the case, they will avoid the merit of the case, go around it, look at technicalities, make a pronouncement or a ruling or an order, and according to law, no matter how ridiculous that judgment is or that ruling is, it has to be set aside. And then we have all these flip-flops up and down. So help us understand how to navigate where we see judges fault or falter in very basic process of law. Is that pure mischief, or there's a strong case presented by the lawyers?
Your question is not lost on me. I'll deal with it. But I think that the background you have given is not just a philosophical one. It's an expose in the jurisprudential challenge that the Nigerian judiciary faces as of today. But please allow me to enter a caveat. And I'm not doing this to patronize any person. I'm not known for that. See, so many judicial officers in this country, very many. In short, if you ask me, over 80% of them are not just upright, they are hard work. You could see the way I'm dressed. I'm in court almost every other day. And we know what we see. However, the malfeasance of a few of them has become not just pronounced, but literally going to undermine what goes on in that sector. This is not to find an excuse for what is happening. It is to re-emphasize and reinforce the point that it is an institution that we should actually be above board. In other words, they ought not to be that 5%, 10% of bad eggs amongst them. This goes back to the question of self-regulation. The way and manner the judiciary is constituted to self-regulate itself, and what happens with that mechanism with a view to getting us to the point where we don't even discuss. Look, me discussing this topic and having it, deliberated in the public space the way we do it has a lot of implications. You see, in jurisprudence that we studied, the notion of justice itself does not disappear at the point where you win or lose a case. I have often said it. It evaporates when the public loses confidence in what happens in the judicial system itself. And there is no faster way of evaporating this so-called confidence other than when you hear issues of conflict, judgment, or anything that will have to do with a confusion in the mind of the people as to the quality and content of justice that spews out from the judiciary. Now, I come to your question. How does conflicting judgment occur? It has been traced to the first inability to apprehend the state of the law timelessly. In other words, what has happened by way of judicial pronouncement in the Kaduna Judicial Division as against what matter, a similar matter that has just arisen, in the Sokoto Judicial Division. So to what extent is it possible to have a technological know-how that brings to the attention of judicial officers timelessly regarding the state of the laws? And when I say laws, I'm talking of judgments and pronouncements and rulings of court in all the judicial divisions of the court. There is a reason why the courts are divided into judicial divisions. That speaks to the question of territorial jurisdiction, and that's the point you were trying to make. There is no basis decent enough that will require you to take a matter in which the cause of action arose in Port Harcourt up to Abuja. When in Abuja, they are already complaining of full dockets. The whole essence of judicial divisions is to have these matters dealt with within the territorial jurisdictions where the subject matters arose, except, of course, in the very few pieces of insecurity. And that insecurity is not a question of conjecture. It must be real, practical, feasible, and palpable. Otherwise, it cannot justify such transfer. So we have quarreled. I was in your station. I remember I was in your Abuja station when this issue was being discussed, right during that election, local government election. And I was also in your sister to say that that was not just anachronistic, it was almost going to be an affront. And it deepens the question of forum shopping, which is almost an irregularity that nudged towards corruption. So here is the point. And this is why I'm a bit elated that my Lord, the Chief Justice of the country, Honorable Justice Kekereekun, has risen to the occasion this time around to proactively investigate, cause to be investigated, the complaints already raised in that direction. Because the laws are settled. There are outlets of judicial authorities from superior courts of record stating this obviously. In short, in criminal matters, that in criminal matters is even more stringent. You remember the case of James Ibori, where the matter, FCC took the matter to the Kaduna Judicial Division. The court, the appellate court, the intermediate court first, and the Supreme Court told them to go back to Delta State. This was how the Honorable Justice Awukule's court was created, although he discharged all the charges against him, which were the basis of his conviction in London. So I make the point that there must be very serious and stringent observance of the rules of the game. It is gratifying that the Chief Justice of Nigeria, who is the chairman of National Judicial Council, has taken up, as it were, this challenge by setting up the mechanisms, the machineries, by which this particular practical example or instance should be investigated. Secondly, it should not end at investigation. We must understand from this practical case what factors, what variables made it possible even in the face of the law, to have this thing perfunctorily distorted in a way that sees a matter that is supposed to be in Rivers State all the way to judicial. Who are the drivers of this process? Who participated? To what extent were the involvement? And how then do they face the law in relation to the transgressions as we see it? Yeah.
And, you know, Mr. Ugwumadu, Jeffrey's question is instructive. If we reflected even on current issues from, you know, this administration, this year alone, we've seen how we cannot absolve the judiciary of blame in the situation in Kano where we had two emirs. You could go to River State where we have two state assemblies presiding over legislative matters for that state. And go back to Kano again, the just concluded local government election, we've had conflicting court orders on the issue. And you wonder if where the truth has become a casualty in the matters that the judges here have presided upon. And perhaps, you know, this drew the concern of former President Goodluck Jonathan, who said, if we're not careful in this country, a presidential election may just be nullified. And I want you to speak to that. We don't know the approach that the CJN may adopt. We don't know how enduring it would be. But if this is not rained upon, you know, for lack of words, what are your projections about the impact on the polity, both at the state level and at the federal level?
Well, the impact is already being felt. And that is what I spoke about when I said it erodes the confidence of the people. Where there is no certainty any longer, where the processes are not settled, and even as practitioners, where you cannot rely specifically on the state of the law, it becomes not just troubling, it becomes very, very discomforting. I don't know, can you still hear me? Because I can see the
yes, we can hear you.
Are frozen.
We can hear you, go ahead.
Very well. So I speak about that because it is at the heart of what mobilizes the society in the direction of a civilized behavior, relying on
we have a challenge with the connection through to Mr. Ugwumadu, but we hope that he will return shortly. And it's important to have this discussion, particularly, you know, with concerns about governance. And that question, Jeffrey, is instructive when we consider the state of things, you know, in River State. Okay, we have Mr. Ugwumadu back. If you can hear me, you can go ahead and land on that point.
I'm back.
Yeah.
Thank you. I apologize, network challenges. So, when you are unable to mobilize the buy-in of the populace in terms of confidence, building sufficient confidence in the process, you have lost more than half what you need for a credible judicial system. And it happens where there are conflicting judgments, where there are very unfounded rulings and judgments. In short, there's one justice, Justice Dimba, I often quote. He said, for a judgment to be a sound judgment, it must first make a common sense. You cannot have a good judgment that did not make common sense. In short, it is at the heart of that confidence that resonates with the people. And when I say the people, ordinary people, not white-collar job practitioners and chief executive, ordinary people. So that is the starting point. The second point is that you are not able to speak with certainty. And to a large extent, even as a lawyer, what would be an outcome of a course of action? So you see, the course of action in defamation is known. The factors and facts that must be established are also known. What you must be able to prove to get justice are also known. Yet, you have very different outcome, even when all the variables are there. That kind of practice does not create the kind of certainty that produces the confidence that is needed by the people. What is the drawback? The drawback is that the people lose faith in the process. The system is shortchanged because indeed there are no buffer zone any longer, which is what the judiciary can profile. And the wider implication is that these people who have lost confidence in these processes begin to think of resorting to self-help as an alternative to that judicial system that was created to establish, civil behavior. That's a challenge.
Mr. Ugwumadu, as we begin to wind down, we cannot take away the fact that, without making a case for them, and I'm happy this government has done one thing that is quite impressive, which is increase their salaries by 300%. So we can't rule out the issue of greed and even threats to their lives in certain cases. But I said that to the effects that, do you think the punitive measures that is being put out is enough to deter the mischievous and bad elements on the bench to stop some of these embarrassing situations we found ourselves? I remember vividly, I think it was a PDP crisis one time when a PDP national chairman was restrained by a judge in Rivers State from parading himself as the national chairman. Another judge unrestrained him, I think in Kebbi. Another judge restrained him again in Cross River State. And all of these are coordinate jurisdiction, all of them. And I think what got out of that eventually was just 2 years or 3 years of not being promoted. What stronger punitive measure, in your view, from where you sit, can be done or put in place by this CJN, or maybe a reform that can really help us to sanitize the entire system as much as possible?
You are right. We need very firm punitive measures, not a slap in the wrist. Because when it comes out or comes across like a slap on the wrist, the signal it communicates is that, well, it is bad enough, yet the society has a way of tolerating that. We don't show enough resentment by reason of the measure of punishment we dish out. We don't show enough disapproval by the conditions of punishment that we give. So I agree with you that we must have to tighten the nose in a way that shows that the society resents what is happening, but to also serve as a deterrent. It's not only in criminal offenders that you should have to put deterrent. However, it goes beyond that. Even the leadership of the judiciary must also exercise very serious caution and remain circumspect in what they do. Look at the recent flag off of the judges' quarter, or what do you call it, at the Federal Capital Territory. The fact that the Chief Justice of Nigeria, my Lord Justice Kekereekun, appeared there has raised a lot of concern within the circle of the people mass. I'm not excluded. And we have had cause to ask very big questions regarding the impartiality and independence of the judiciary. If we could have this kind of thing play out very perfunctorily in a way that suggests that, it doesn't matter. It does matter. And that question has been pointedly put across. Supposing Julius Berger, which is a corporate entity within the laws of this country, decides to challenge that revocation, what manner of justice do you think that they will get? We're not saying they will go to court or they've gone to court. In fact, it is even believed that they will not go to court. But that is a scenario that enables you appreciate the point that we're making and the need to continually remain second. I mean, it's a very peculiar lifestyle. The judicial officers and the judicial sector of every country is not something that play to the gallery or one that can be found wanted. So difference is there. The strict observance of the ethics of the profession and the oath of office Then remuneration, which is happening already. At that point, whoever decides to now become an outcast will be shown the way out. Then what is the infrastructural reinforcement and development around the judicial system to secure speedy dispensation of justice? What about the training and retraining that must necessarily go on, because they are human beings like you and I, and knowledge must be refreshed and improved upon, otherwise you are receding. What about the work tools and the work environment? Then how does the society treat the judiciary? Up until very recently, if you hear what they receive, you would know why they are susceptible and vulnerable to these malpractices that are attributed to them. Then how do we defend them? What is the reward system? There are many of them, and I say this in pain. I know so many judges, not because I visit them, but what we subject them to in the courts of law and how they deliver.
And you know,
processes of over 400 and something page document on the post site and try to navigate it and come back with a ruling. So those ones need to be protected.
And you know, Mr. Ugwumadu, if you talked about their remuneration, some would say that there are justices who have been above board and have survived the pressure from the executive. And you could talk about Justice Datijo, who raised serious concern, upon his retirement from the Supreme Court. And one wonders why the influence of such justices does not permeate down the lower rung of the judiciary. But we must thank you very much for balancing the conversation this morning, for providing your robust knowledge. Thank you so much, Mr. Malachy Ugwumadu, a lawyer who has come through for us on this very important conversation this morning.
Thank you. Thank you.
Yeah, and so that does it. You know what they say, if gold becomes iron, what happens? If iron becomes copper, what happens? If the foundation be destroyed, you can complete that. From this point, we'll move on to the next leg of our conversation, which would be that strike that has crippled activities in Nigerian universities. Stay with us, we'll be right back.